significant impact, and finally deal with the transfer pricing aspects that any such, say, IP or intangible related case will have. Well, before 2020, as you see, I've taken a picture as an eye catcher that's somewhat older. It's our former Minister of Economy in the 50s, and later Prime Minister Ludwig Erhard, who was the father of the German Wirtschaftswunder. The thing that we're dealing with here is actually even older than him or his political career, at least. Before this year, what we usually saw in terms of transactions involving IP rights that applied withholding tax would usually be where payments of royalties would come about to non-German recipients. And until 2009, there was also a withholding tax if you sold IP rights from and purchased them from a non-German seller. So if you paid a purchase price as a German resident to a non-German seller of IP rights. However, the requirements for withholding tax were always only relating to German resident taxpayers, and that was the practice as it was applied. For non-German taxpayers, the prevailing view was always that since they're not under German jurisdiction, they should not be subject to German rules. There was no significant case law, though, on this, and the ultimate end result was that you required a German nexus in order to apply taxes. All of that suddenly changed in 2020 when an analysis that was brought on by several of the big four companies sticking their heads together and thinking about cases that they may have had in the last couple of years came to the result that probably Germany might claim a higher taxation right. And once they had made up their minds that this could be the case, what they did was run around and actually scare all of their clients, and in doing so, destroying their good faith in that whatever they may have done so far was okay. Essentially, much of an action to produce a lot of extra work for these companies, but obviously not greeted with too much appreciation by all clients. What does this relate to? If we go to the next slide, the German nexus requirement, as included in our law, is relatively simple. If obviously you have IP license to a German tax resident licensee, or you have a German tax resident licensor, as I just said, you would always have issues with the German right of taxation. However, Germany also claims that there is a nexus where registration is done in a German register. So if you have German patents, German trademarks, then obviously Germany also lays claim to a certain right of taxation on these. As you can see on the right, that's the European Patent Office. This is located in Munich, and since Munich is part of Germany, Germany says that anything registered in the European Patent Office also is registered in a German register, and therefore should give rise to a German nexus, and therefore to a German right of taxation. Ultimately, there's just recently been a circular letter published by our Ministry of Finance, and they said that under certain conditions they might also see that any registration in the European Trademark Register could qualify, which is somewhat peculiar because that's located in Alicante, Spain, so well outside of Germany. Nevertheless, obviously, it also registers for Germany. I think in essence, where this does play a role is if you register a European trademark, the process as such is that you are allowed to tick a box and say, please also provide me with domestic trademarks in member states X, Y, and Z. And if you tick the box for Germany, then you will ultimately end up also having a German trademark register. And I think that is what they are trying to cover. In all these cases, we now see that the Finance Administration, having been asked by taxpayers and approached by taxpayers, has taken the view that even if neither the licensor nor the licensee are German, the transaction should create a German right of taxation. In practice, this is something that is something you need to be aware of. So if two, say, US corporates trademark groups or bulks of trademarks, IP licenses, royalty, patent rights, and whatnot, a purely domestic US transaction covering their worldwide patent portfolio, for example, will trigger a certain degree of German taxation. This has quite significant legal concerns to be aware of course, because Germany is applying its domestic law to people who are not resident in Germany, who have no permanent establishment in Germany, and no other nexus to Germany other than potentially a simple registration before the, say, European Patent Office or a German trademark or something registered in their name to make sure nobody wreaks havoc with their trademark names. You can imagine that if you have two, as I said, US corporates in my example, doing such a transaction, they may probably not have looked into the detail of every single jurisdiction whose IP rights a transaction of that kind might have covered to ensure that this is properly taxed. You may also imagine that if every country in the world took the approach to say, well, in that case, I'm going to have a chunk of that subject to my local withholding taxes, you will come to a point where you will easily end up in a large dispute on which country gets to tax which part of the revenue. To sort of cushion the blow a bit, if we go to the next slide, for some transactions, we may be relatively safe. Wherever you have treaty countries that Germany does have tax treaties with, and we are a country with a relatively vast network of tax treaties, you will end up within the perimeters of the treaties. These are much smaller, as you can see. Royalties are only usually taxed in the recipient's home country, and the same is essentially applicable to the sale of IP rights. The only exemption is where IP rights are somewhat attributable to a PE in the other country. So unless you'd have a German PE, all treaty-covered transactions should be exempt from this nexus issue. That said, though, and that was one of the things that sort of shocked us a bit, given the huge amount of work that we're now seeing in these transactions, as I said, recent, as in the last 7 years, transaction that involved inter alia German IP rights being reportable, the German revenue says that even if you are treaty shielded, in order to fully apply the treaty, you essentially need to either get an exemption certificate prior to the transaction, or if you haven't done that, you need to actually file the withholding tax and then claim for a refund afterwards. So what they are now doing is they're blowing up a huge administrative burden on all the companies that have failed to ensure that the respective exemption certificates were available when the transaction was initially started. And therefore, we will see a lot of procedures where clients will need to first remit funds to the revenue and then try and get a refund. And quite frankly, the Federal Tax Office in Germany, which is in charge of the refunds, has always been chronically understaffed and obviously will not be able to process these refunds in a very meaningful short period of time. And that may well result in quite significant issues. As you see here, the difference between royalty income and IP right income, I think the cases where you pay a global royalty that's not broken down into individual countries is in a proper transfer pricing setup relatively rare. So I think royalties are not the main area to focus on. It's more the sale of IP rights that really worries us, because we see a lot of clients that have, either by actively selling portfolios of brands or patents, or by contributing these through chains of ownership from one entity to another created several transactions which might give rise to a withholding tax obligation, or at least a withholding tax reporting obligation in Germany. As you may imagine, many IP-related transactions involve entities in offshore jurisdictions, which tend not to be treaty eligible. And for these, if we turn to the next slide, the situation is much more dire. The map you see on the right, I've nicked from our Federal Ministry of Finance's website. It shows everything in yellow and brown is a country that we do have a tax treaty with. Gray is a country that we don't have a tax treaty with, and blue is where we're currently negotiating a tax treaty but don't have one. So the gray area, and particularly also the ocean in between, play a huge role in many of the IP-related transactions we've seen in the last couple of years. And all of those Caribbean islands that are at best blue, if not gray, also play a significant role. These countries are all in scope of our more threatening taxation aspect because you don't have any treaty protection. And Germany, by virtue of its pre-existing tax laws, which actually predate the League of Nations even, trying to at least get some sort of nexus applied, but predominantly through withholding taxes that you would levy from a German resident, are now applied to these third country jurisdictions. And every transaction, whether a sale straightforward or an onshoring or contribution transaction that you may see, may fall within the scope of these rules. And the German revenue is quite aggressive in saying everything falls within these rules and is making you susceptible to German taxation on these issues. So far, so good. Again, and now in what I would say a vast example of overstepping the limits and lines of a fair trial, Germany has also said that they are willing to collect these taxes from those companies that have already come forward and have told the revenue about the fact that they have such transactions, but will pursue all companies that have not done so on a criminal basis, because by now everybody should be aware that this should be an issue. Now, given that you're the managing director of a Puerto Rican IP company of a US corporate, it's quite interesting to see how you should be aware of these developments that currently go on in Germany. And then if you fail to report something that you're not aware of, be held criminally liable for it. But it is at least the approach a German revenue is taking. That said, the statutes of limitation I already mentioned are rather long. If you say that no tax criminal offense has been committed, then you have a 4-year statute of limitation, but that only starts to run as soon as you have done the underlying tax filings. If you don't do your tax filings for these transactions, you add another 3 years to the statutes of limitation. So in any transaction where non-German residents are concerned, these will quite likely not have filed German tax returns. And therefore, the statutes of limitation date back 7 years for these companies. Failure to do anything this year may, by the German revenue's view at least, be interpreted as a tax crime, which would then further increase the statutes of limitation, and therefore is something that they see as a potential way of threatening. You also see that the reporting obligations are quite vast, because you need to see what transactions were done, how did they involve German registered IP, and you need to identify this in the first place even, which is not that easy, because obviously where nobody thought of Germany in particular, there will be no particular individual record that you can rely on. We do, though, feel that the view taken by the revenue is quite excessive for several reasons. One, it's, and you probably feel the same, it is a quite overreaching taxation. If you just tax non-residents on something by the mere fact that it's registered in some registry, and if you don't know which one this is, that sort of doesn't help either. So if you say like the European trademark register would apply, I think this is way overreaching. The European Patent Office has long been held, even by commentators, as not sufficient to constitute a German register. And I think that technically that argument is absolutely valid because it's a European institution, not a German institution, although it obviously also covers our territory. Also, you apply German tax laws to non-Germans, which I think in particular, if you also put significant reporting obligations and criminal law threats on them, is overreaching. And thirdly, a very valid argument is that we've had these rules since the 1920s, and it's never been knowingly applied to a mere non-German transaction. And we usually have a constitutional aspect of fair treatment of all people involved, which says that if you strategically do not enforce laws such as this one vis-a-vis third party or third country residents, then you can't go after one of them and say we'll just drop it for the rest, because that would not lead in a level taxation. And finally, if you have a transaction where you hold the German licensor or the non-German licensor liable for a tax that he only has to withhold as a withholding agent on behalf of another entity, that probably is a misuse of your discretion as revenue authority, because you probably need to collect from the taxable person rather than from the withholding agent if that is also not a resident of your country. Well, that takes us to the last slide that I was hoping to present on this, which is there's one further thing to bear in mind. Transfer pricing wise, there's a couple of questions that need to be answered, and that also play a big role in this overall equation. Is there indeed a separate royalty for Germany, or a royalty stream that you could allocate to German registered IP? If you take, for example, a patent that you may have, you will probably also have third country patents, and these may be predating the German patent. And the only way or reason for you registering domestic trademarks or patents is for easier prosecution of abuse of your patents or violation of your patents. So you register German trademarks because German trademark infringements are easier to enforce in Germany, and the same applies to German patents. But if you have a US patent, for example, under mutual agreements on fair trade, you will also be able to have these patents safeguarded in Germany without a specific German patent ever having been issued. So the added value that a German registered right might give you, which could, on the transfer pricing considerations, be subject to German withholding tax obligations, is relatively small potentially in many cases. And the same obviously applies to IP rights. As I said, where you have European trademarks, these may generally be just a reflex of a European trademark if you register something in Germany. Now, this is an issue that has come up only this year. It has been peddled by the Big Four quite substantively. We have seen that while the revenue was quite open to discussions on how to deal with this at first, they have quite recently had a joint meeting and have in that meeting agreed a rather strict line by which they now give you very short periods of time to report back. If you identify a case, you go to the tax authorities, say we still need to pick up the numbers, we need to find all the relevant agreements and whatnot, they will probably give you 4 weeks max to get these documents together. And whoever has ever worked for a multinational knows that for non-German transactions, to find out whether they have some sort of very remote nexus to Germany is a very, very long and exhaustive task to go for. And we see that many of our clients are struggling to get the information together in the time frame that they're being set by the authorities. Also, as I said, for the treaty cases where it's clear that there's no fraudulent action and no actual taxing right of Germany that's being violated, the authorities have abstained from granting some sort of relief provisions or allowing you to report that later and then just have it cleared without having to withhold and then refund the taxes, which I think is also very unfriendly, at least as a step of the tax authorities. Why is that? Obviously, you know that the media climate towards corporates is very harsh. And we all know that in COVID times, funds are something that revenue would like to collect at first and then see whether they need to remit them later, because they need the money now. We have an election coming up next year, and everything they've collected before then is on their good side, and everything they need to refund then is a problem for the next government. Well, I think that was a quick run through my end, and I'd like to turn to Lars, our co-panelist, to give us a bit of an outlook at how other countries deal with these issues. I think some of the underlying questions on how you treat nexus may be not so different, at least on paper. Lars?
Yes, thank you very much. This is very interesting, and hello everybody. Of course, Gunnar and I had a discussion on this before, and I knew that we have very similar rules in Austria. So in general, our tax systems are in general quite similar, in detail very different. However, I was aware that we have a similar rule here in Austria, and I was very curious to learn about the business development strategies apparently of the Big Four in Germany. So it's basically nothing else than providing for your own business there somehow, because nobody would get the idea that simply because of the registration you would really go after this. However, nevertheless, when I read through this in Austria, so from a legal point of view, we have basically the same structure. So you have a structure where you have, when you start, of course, when you have a licensor resident in Austria, this person collects the income. So of course there is a right to tax. This is quite clear. And then when you have the licensee, it becomes interesting because there is another, typically you are taxable here, but if you look into why the licensee is taxable here, it's typically because whatever the license is about is somehow exploited in Austria, or in the other case, it would be likely Germany. And this somehow mixes up with the registration issue here. So it's formally exactly like Gunnar says it. So simply having it registered here would allow by law to tax this, even if the licensor and the licensee are resident outside of Austria. However, here in administrative guidance and even in case law, typically reference is made to the exploitation within an Austrian PE. And now the interesting part here is that this is not necessarily a PE of the licensor or the licensee. This can be a third-party PE. So apparently there's some kind of nexus where we may come to a similar conclusion as Gunnar says it, but it's not like typically you have a non-resident taxpayer subject to limited tax liability in Austria, and typically you can only tax this person if this person has a permanent establishment in Austria. It's apparently sufficient if any person here has a permanent establishment, but typically here it's the licensee then. So typically the case is you have a model shooting, somebody comes here, earns some money. This person, of course, does not have a permanent establishment in Austria, this top model from overseas maybe. However, since this is exploited in the permanent establishment of the licensee, you will nevertheless have the taxing right of Austria. So what I'm basically saying, Austria for now, maybe but hopefully not. They learn from Germany. Does not focus on the registration argument. However, takes a very extensive approach if it's about nexus here as well, but comes from a slightly different direction. Registration is the same with the patent or the trademark. So this is can be in respect of either the license or the licensee. From a material point of view, you typically can get out of this with one-off payments. So typically sales are not here, but this is maybe a different issue. Interesting is typically for these payments, you have withholding obligations. Interesting would be because Gunnar, you also said before that they want to have the withholding tax now and you can claim refund later. typically here you would have no connecting point for any of the parties to pay withholding tax at all in Austria. So I would, from an Austrian perspective, come to the conclusion that there is no withholding liability. So the taxpayer is such who registered maybe or who is it at the end who has to pay the tax there, that this person would simply be in breach of its obligation to file a tax assessment in Austria. But I would not see who is liable to levy withholding tax here. And yes, and then of course there are typical limitations. So like in tax treaties, Gunnar already talked about this. If it's within group companies, you may have a chance to get out by the Interest and Royalties Directive. However, obviously the authorities are not going after these cases. And yeah, legal concerns is likely point for discussion to raise it. Enforcement is the other issue. So how do you enforce it if there's simply a registration in Austria, but licensor and licensee are outside of Austria? How do you go after your tax payment here? And yeah, so in conclusion, very similar but different. So the same conclusion as we come in between Germany and Austria many times. We will see what the future brings here, and whether Austria pursues a same extensive approach as in respect of the registration there.
Great, thank you, Lars. Do we have any questions from the auditorium, which we would address now? Otherwise, we'd just address a few points that are of relevance that may be very, very important. In the absence of third-party questions, a point that you mentioned, Lars, which I found quite interesting, is indeed the withholding obligation. We usually impose withholding obligations on German resident payors of taxes. Mm-hmm. And it is a general principle of our law that it should only apply in these cases. But we have indeed in this very particular case seen that the fact our law is relatively ambiguous on this and doesn't say that you need to be a resident in order to be a withholding agent, which derives originally from changes and amendments to the law that were introduced to tackle cases where in that case, Austrian intermediate companies were used for sporting and music events, which also fall under the same provision for withholding taxes, and where by interposing a foreign entity, you would try to avoid a withholding obligation, which would then be the final tax for the artist. And in order to address that, the domestic residency requirement has been dropped from the withholding provisions. Obviously, it doesn't make sense to apply this to a third country entity to a certain extent. But what, in theory, we haven't seen this in practice, but if the threat of criminal investigations is already out there as our means of enforcement, one way of dealing with this is obviously, if you know there's a registered trademark or patent, you can indeed attach to that in terms of a preliminary freezing order and stuff like that. And base that on criminal prosecution rather than on tax collection provisions, which is harsh, but something that I would not be surprised to see. At the same time, I said one of the main arguments that we say would contradict even collecting taxes like these in a mere third country situation is the fact that there is no enforcement that has ever taken place so far. Obviously, one of the reasons for that being may well be that tax authorities weren't aware of their right to tax. But with that now being known, they are starting to at least make statements that they're willing to see these funds. And obviously, in a multinational, I think the inroad they have to getting into that is to try and find whether anybody locally is involved in the use of that patent, and then incriminate him in the criminal investigation, and thereby sort of motivating the company to go file and then pay. Mm-hmm. I mean, we also have administrative assistance treaties and within the EU, where I think this is not really a proper case, but with everything outside the EU, we have quite a lot of administrative assistance cases in the countries where that applies, though, I think we usually would have treaty protection, where at the end of the day, not much money will end with the revenue. Where we have offshore jurisdictions, a certain degree of administrative assistance may be available, not too much, though, I fear. And I think that is a good argument to say that you're not coherently collecting this tax from all taxpayers. However, we'll have to see, and we know that for many larger corporates, the idea of being sort of involved in German criminal law investigation for tax fraud is something that their corporate social responsibility doesn't really go well with, and therefore the threat is more of a twofold one here, and it's being used to sort of, well, extract money from these companies. And I think it's, as we said, one of the trends that we're seeing where the revenue, by sheer thought that they're the good guys, feels entitled to pretty much everything.
Yeah. Well, maybe just we have similar discussions, so on a more abstract basis. So of course, now not in this respect. When you say you have an argument that you can simply state they did not enforce the law, therefore they cannot simply start doing it now. So maybe they can, but at least they cannot go after criminal charges and things like this. I think we have similar arguments here by Supreme Courts even, where you would say, yes, this is quite similar, but here it would be only arguable if there is a hindrance in enforcement, so that they are not able to enforce it equally, and thereby it's a breach of the principle of equality here. However, if they would simply not go after some, I think this would be way more difficult to argue. So it's not whether it's willingly not going after somebody or not being able to go after everybody. So if the lack in enforcement is on a structural basis, then this may be an argument to avoid taxation for the people they go after. So this is just on a more abstract basis a slight difference here from my perspective, but maybe there are also structural hindrances that would even strengthen this argument.
I think we have to see this in this very case as a structural issue, because obviously if you collect it from nobody, even if you don't have an objective hindrance for collection, the fact that you have never ever done anything about it sort of is more of a structural issue than an arbitrary decision will go after the companies from A to Z and leave D through Z open. But that's not the case here, and that's why I think there's not too bad an argument in this, although we've seen that our constitutional court, having created the argument quite a while ago, has ever since tried to, retreat to its original position, not to allow this as a main argument as much as possible, because they've seen that you could bring it quite often and have tried to actually revert that a bit. And therefore, I don't think it's one that I'd say is a safe bet to rely on.
Yeah. Well, and there is a structural argument as well, because they simply cannot know for everybody. So they would really have to go through every registered patent and see whether there's money earned with it at all. So they cannot go after everybody.
And the other thing is, you merely go after the registration as such. Any derivative sale of the patent would not be captured, which again is something that doesn't really tie in. So if economically you obtain the same result, but don't just change the registered patent holder, then I think there's a valid argument to say, if you get the one case and leave the other one out, this is by no means appropriate.
But this would be the same under general rules. So if the licensee is resident and the patent is sold, there would be no money either.
Yeah, true.
No cash collection either. Yeah. And then of course one interesting aspect here is of course when in case of a PE or anything, you would always ask the question, okay, we somehow have nexus, but what portion of income or of the value or whatever do we actually attribute here? And this is maybe also the difference between the withholding and the assessment argument there. So for withholding, it's quite clear. It's a certain percentage of the paid amount. If it's an assessment, there is no clear rule. Then I don't know whether the question could also be what value is attributed to the mere registration. I think you brought this in your presentation as well. So what is the value when I'm registered in several countries? Can, under these rules, basically every country could go after me. So and there would be no relief in this respect. So question would also be, compared to a PE, what is the value attributed here, or the tax payment attributed here?
Yes, I think that is one of the main aspects that we're seeing, because the offshore or non-German taxpayer involving cases tend not to be restricted to a transaction involving solely German rights.
Mm-hmm.
So you'll have a payment for a global trademark or a global patent, and then you need to break out how much of that is attributable to the German registered right. And it's not just the rights that also cover, not just the German market segment, but in fact the one that triggers the tax obligation, which is just the German registered right. And I think that is a fair argument to actually reduce the value of whatever you submit to German withholding taxes quite below, say, a mere market approach, a market-based approach. So, for example, if you as I said, if you have a European trademark, you may have a German trademark registered solely because it's easier to claim infringement of the German trademark before a German court than claiming infringement of the European trademark. And that makes your legal fees dissipate a bit, but it doesn't really help you in protecting the European trademark more than you have done before. And therefore, the beneficial added value that a third party might pay will be nearly nothing, because you can't use the IP right on its own without infringing the European one. And in that case, I think there's a good argument to at least remove quite a significant amount of this this fund from the German right of taxation. Mind you, though, that in enforcing in claiming your taxpayers' rights, you'll always have one obstacle. As I said, we have an line of defense for treaty protected countries, which in the end is just pay and collect the money back again. Where this really is a cash, has a huge cash impetus, where you have non-treaty countries, the likelihood that you have any other means of getting your taxes back other than by domestic litigation are very low. And if in a domestic litigation you claim that the income would be attributed to somebody in an offshore jurisdiction, even though on an objective basis you may be right, the fight you have in convincing the revenue and the tax courts that this is true and good are much higher, not on a technical, but on a more emotional level, which unfortunately does influence decisions.
As usual, yes.
Well,
yes.
I think with that, we are through with this subject. And if I am correct, then in 2 minutes' time, we will go to a general closing session, and everybody will be redirected to that session automatically. And I would give you 2 minutes to refresh before we do that. Thank you for your attention. Bye-bye.